Well, good morning, everybody, and welcome to our Decision Making and Vulnerable People webinar. My name is Philip Warford, and I'm the Managing Director of Renaissance Legal, and it gives me great pleasure to be invited along to speak to you today. Luke is with us from the TSA, and he'll say a few words in a moment, but I'll just do the scope of what we're talking about today. We are recording the presentation today, and we're doing that deliberately because I know a lot of the families linked to TSA will be watching this in the evening. So in true lawyer style, I have to do my disclaimer to say today is the 20th of March 2024. Everything is correct as at today's date, but the law changes so frequently. So if you're watching this after the live date or some period after the live date, do just check that the facts remain the same. So that's the disclaimer. Every lawyer does it. Sorry about that. We can then crack on. So the style of today is that I'll be doing a PowerPoint presentation. I don't read from the slides, they're there to support what I'm actually explaining to you. I'll try and make it really live because we've got the interesting sort of cross-section of people with mild TSC who will have capacity themselves, and I'll talk about what they can do to help themselves and to facilitate decision-making. And those of you who support people with significant support needs on TSC. And for those of you, families, carers, it will be talking about how you can actually help those people decision make for them. After today, you will get a copy of the slides. We are looking to run this for roughly about an hour, and then we'll do 15-minute Q&A at the end. So if I can ask you to hold off your questions until the very end, that would be greatly appreciated because it becomes like a bit of a fireworks show on this side of the screen. Things are flashing up, and actually I won't be answering anything during the presentation because it kind of flows through. And so sometimes you'll post your questions and they're answered a bit later on. But we will have time later on to do that. So I'm going to hand over to Luke just to say hello from the TSA. So Luke, over to you.
Yeah, thank you, Phil. That's excellent. Great. So yeah, I'll be very quick so we can hear more from Philip at Renaissance Legal. But yeah, just to say very shortly, we're absolutely delighted to be able to have this event. It's a we get lots of questions on the TSA support line, all about decision making, power of attorney, and things like that. And this is an event we've been really keen to do for some time. And Renaissance Legal have been fantastic with us, just so everyone knows. Very happy to do this event, for example. Yeah, so everyone on this call will be aware of obviously who we are and everything, but you do keep us in mind in terms of the TSA support line if you've not used us before and things like that. So I'm very pleased to have this today because it's such an important area for our community. So yeah, I'll not say anything else. I'll hand back over to Philip now. Thank you.
Great, thanks, Luke. Luke, I'm just going to take you off panelists so that I can see myself. And I'll put you back on at the very end so that you can speak again. So just bear with me whilst I do that. Hang on, sorry, technology. There we go, I'm moving you over. So I'll see you in a bit, Luke. Thank you. So let me stop my share and reshare the slides so that we can go properly live. So bear with me, sorry for the horror of seeing my face really big on the screen. There we go, great. As Luke said, we have been working with TSA just really for a short period of time, and TSA came across us because we do lots of outreach work. So we are a specialist solicitors firm, and we specialize in working with families to support disabled and vulnerable people. And that might be in the arena that we're talking about today, which is looking at decision-making, capacity, those sort of things. But also, actually, we set up wills, trust structures to make sure inheritances are protected for vulnerable people. We're based in, I always say sunny Brighton, and sometimes it's not. We're based in Brighton, and it is sunny today. but we actually have clients all over England and Wales. And that's because one of the only really good things to come of COVID is that we all kind of went online. So actually we do the majority of our meetings on Zoom, Skype and Teams. And as you'll kind of see from my setup today, I'm actually working from home. Although clients are very, very welcome to come into the office, we actually do most of our client meetings online. We also do lots of outreach and education and empowerment. And that's really what today's about, is about sharing my knowledge with you so that you can go forward and make decisions that either help yourself as someone who has TSC, or indeed that you can support someone with TSC. So we do lots of work, particularly with MainCap, NAS, Contact, Scope and Sense. This is the fantastic team, myself, Catherine, Stuart, Gina, and Sarah, who you'll see a bit later on because Sarah's going to help me with the Q&A. So if you engage with us after today, you might see myself or indeed one of my colleagues. So let's crack on and actually get stuck into what we're doing today. I have broken it up into sections because it tends to be easier to understand this way. So we're going to start by thinking about how and why things are relatively straightforward up to 16, what then changes at 16, quite a big change for those of you who have been through transition. So we're going to look at the assessing of capacity, decision making, what happens where there's no capacity and we need to make decisions. And then we're going to go on to the post-18, where there is capacity and we can do things like lasting powers of attorney, and then wrap up with some other things which are quite interesting but don't fit into those categories just at the end. I'm going to try and make this live in terms of the examples, and I tend to use the example of a parent to a vulnerable child because we support lots of those families, lots of that dynamic. So my working examples may not be with someone with TSC, but maybe other vulnerabilities. So the starting point, up to 16, things tend to be relatively easy for us. And that's because we have something called parental responsibility. We are the parents, we're responsible for our children. It's exactly what it says. So actually, we tend to go through life making decisions for our children, be it health, social care, medical, where they live, education, all of those things without any interference. And that's because of that inherent parental responsibility. The only time that we tend to find that we are questioned to a larger extent and that lawyers become involved are things more linked to life-limiting decision-making. And I've put there the very sad case of Archie Battersby, which you may remember a couple of years ago now, 2022. Archie was 12. And he suffered from a catastrophic brain injury, believed to be as a result of him choking whilst watching a viral social media challenge. The conflict that resulted in the need for the court to intervene was that the family wanted Archie to be kept alive. He was on life support. Thinking that there could be some developments in the future, that he may actually get better. And the medical professionals were saying that that wasn't a possibility, that unfortunately he will never recover from this. And the life support was keeping him alive. So the case had to go to the court. It was very, very well documented. Lots of very sad facts around it, very, very emotionally charged. So realistically, what I'm trying to explain here is that up until 16, we tend to go through life unchallenged unless there's something fundamental which tends to be a life-limiting decision. However, post 16, things completely start changing for us. And that's because of the Mental Capacity Act. And I'm not saying that in a negative way, because actually it was a really positive thing when it came in. But it underpins everything going forward in terms of decision-making, the court of protection, lasting powers of attorney that I'll talk about in a moment, largely from the age of 16. Pre-2005, we had a number of different laws, cases, things that were all a little bit disparate, and it was very difficult as lawyers to know exactly where we fitted, and where we got conflict, it was really difficult to know exactly how we dealt with that. So it took a few years for this to come into effect. Interestingly, as it was going through Parliament, it was called the Mental Incapacity Act. And thankfully, someone at the very last minute realised that incapacity is a negative term and we want this to be positive. So this underpins everything going forward. And what we're saying here in this sort of section is that we have a big question and we want to see whether the person who the question relates to is able to answer that and deal with it themselves. And if they're not, then how do we deal with it? So the Mental Capacity Act actually has 5 core principles. And a lot of the sort of talk today and the thing that you might be coming into contact with comes back to these because they're the sort of fundamental starting points. The first 3 that I'm going to talk through now tend to be the positive, the empowering, the more capacity related, and then I'll talk to you about the other 2, which are relating to people who lack capacity. So the first 3, we start with a presumption of capacity. So when we're looking at decision, and let's say, for example, the decision is, where is this individual going to live? You know, maybe someone who's 23 and we're now thinking about them leaving home. We start with saying, can they make that decision for themselves? We're starting from a they can unless proven otherwise. So it's a very strong starting point. In the decision making of that question, we're saying they do have capacity unless proven otherwise. Now, for some people, it will be clear that they don't. For some people, it will be clear that they do. And for some people, it will be a bit of a fudgy situation in between where we need to think about, as we'll talk in a moment, how we actually assess capacity. The next core principle is that we all need to work together to maximize the decision-making capacity of the individual who is making that decision. And we'll talk on the next slide about things to think about when we're doing that. But again, it's a really powerful start because we're saying, let's try and encourage that person to do the decision, to make the decision if they possibly can. But what we are then saying is that if that individual does have capacity to make that decision, then they can do something that we don't agree with. So they have the right to make unwise decisions. And, you know, you and I maybe make unwise decisions on a daily basis and learn from that. You know, whether we have a coffee after 3 o'clock and can't sleep at night, that's an unwise decision, which I would say, well, don't do that. But you think, oh, I'm going to. We can't stop someone from making unwise decisions where they have capacity. And that's really difficult for us as parents because, particularly in a money context, if we're saying they've got capacity to manage money, then they also have capacity to make mistakes, as you and I have, as we've grown up through our lives. So when we're looking at the decision making, we look at the transaction because what we're asking for the person to make a decision on is fundamental to knowing the level of capacity that they need to have. So, for example, capacity to choose tea and coffee this morning is maybe at the lower end of the scale. Capacity to manage a stock and share portfolio at the higher end of the scale. Capacity to make a will, to make lasting powers of attorney, they're all different. So in one day, we might have someone who has capacity to do things kind of down here, but doesn't have capacity to do things up there. So we always start by saying, what is the decision that needs to be made? It's transaction specific. And then maximizing decision-making capacity. Think about things like time of day. Who here is better in the morning or better in the evening? We're doing this in the morning, probably more so because of me than anybody else, because I get up at 5 o'clock. I go to the gym from 6 till 7-ish. My day starts at sort of 7:30, 8 o'clock when I get to work. But actually by sort of 5, 6 o'clock, my day is coming to an end. So actually running a webinar for me later at night doesn't actually work so well because my capacity, I'm tired by then, I'm pretty exhausted. So actually, like I said, that's probably why we've done this. My team have manipulated this for me because they know that I'm better right now. So time of day does affect your decision making. As does medication. You know, some medication's soporific, you take it before going to bed. Some medication lifts you. So think about if we've got medication that's going up or down, when is the best time to make the decision and facilitate the time around that. Surroundings, massive thing. Who feels comfortable going to the dentist? If the dentist came to you and saw you at home, would you feel more relaxed? I had a client, I'm going to use this lady quite a few times in our examples. She has Down syndrome and she is 23. And after one of these talks, the parents said, I think she can make a lasting power of attorney and that she'd be happy to come into your office. So we got her in, and literally I could see the shutters down, the fear. I was in shirt, tie, suit. She was in a lawyer's office, which is, not the world's most fun of places, and she just wouldn't communicate with me. However, I could see that there were glimmers, and so we actually arranged for me to go and see her at college. We went into a quiet room where there was her artwork on the wall, and she absolutely opened up. So surroundings can affect your capacity because you could feel really tense. And communication, like I said, it's communication, dress, everything can look and feel a way to make you feel more safe. And just because the communication that I'm doing today doesn't actually work, doesn't mean to say someone doesn't have capacity. They may be using eye gaze, they may not have English as their first language. So just because someone can't communicate in this way does not mean to say that they don't have capacity. And temporary illness. Things like a urinary tract infection, for example, can kind of take away your capacity for a couple of weeks until the antibiotics kick in and then you stabilize. So a temporary incapacity doesn't mean to say that you can't make that choice, that decision in relation to that one thing. You just delay the decision making to the time when you're feeling a little bit better. And the same for age. This comes up a lot in the questions. Just because someone can't do something today doesn't mean to say that they can't do it in 2 years' time, when perhaps with a learning difficulty, they have more time to be educated. So who assess mental capacity? This is actually a really difficult slide because it is a real changing arena, because I've got healthcare professionals up there, but actually just recently, most healthcare professionals are saying that they won't do it. And that's because their guiding organization has given some tips to people to not do that because you can be held to account. So social care professionals, like, for example, a local authority, again, they may do it, but the likelihood is they won't. I've got someone experienced in mental capacity. So, for example, we as practitioners often use independent specialist capacity assessors where we have a particularly challenging case. And that's because if we're doing something based on someone having capacity, and that might be challenged in the future, and we might have to go to court to defend it, it is much better off getting a absolutely watertight assessment so that we know if it's challenged, then we're going to be in the clear. So, basically, we kind of tend to look at the question and say, well, who's best within these categories to make the capacity assessment, approach that person, see if they'll do it. You might need more than one, but actually, if we're trying to secure the decision that this individual is taking, we might need this. And actually, for us as lawyers working in this area, because this is our specialism, we actually have capacity assessments for a vast majority of things that we do where people's capacity may be in question, indeed now or in the future. I put there what actually needs to be done, because actually what tends to happen is people come to us and say, my friend's got A, I want A, or I want this, I've read something. And the way that we work as lawyers is we always start by saying, what are you trying to achieve? Let us figure out what's best for you and the pathway through that. But start by telling us what you want to achieve, because there are time implications, financial implications, things that you may not know about. So coming to us with a more open mind really helps us facilitate the way through, and actually the most economic way to achieve the end result. Because sometimes it's us saying, don't do anything because the law enables you to achieve what you want. So that's our kind of sort of, I say positive, I don't mean that in a strict way, but that's our kind of starting point where we say this is how we facilitate people to make decisions for themselves when we've got these big decisions to be made. But if a big decision comes up, again, using that example of choosing where someone lives, and the individual does not have capacity, then someone has to make the decision for them. And the final two core principles of the Mental Capacity Act, best interests and least restrictive option, come into play here. Best interest we're going to talk about on the next slide, but basically it means that every decision made for the individual has to be in their best interests, has to be right for them. And the least restrictive option, this is really interesting and very important because the court uses this quite a lot to say, I'm not going to intervene. So let me explain what this means. And I'm going to give you three sort of paragraphs or sentences that gives you an overview. So it could be said to be keeping a person safe whilst respecting their rights, something that would interfere less with their basic rights and freedoms, and the least restrictive way to meet the decision or need. So everything is about taking the simplest possible route. And you'll see when I talk about the Court of Protection in a moment how that really plays in. So best interests, that is the fourth of the 5 core principles under the Mental Capacity Act. What that says then is where we have a decision to be made and the individual lacks capacity and they're 16 plus, then the decision has to be made by a multidisciplinary approach and in that person's best interests. So it's thinking about what's right for them. And you as parents should be involved in that because you have all of that inherent knowledge. One example of this, which is really quite useful, it was quite a long time ago now. There was an elderly person in a care home next to the church that she went to. And she went there all of her life, which is why she went into this nursing home. When prices got expensive, the local authority moved her from the nursing home to somewhere cheaper. And they gave a fudgy reason about why they did that. But actually, when the family appealed that, they looked through to see what was going on and said, actually, you didn't implement this. You didn't think about what's right for her. And what was right for her is to stay beside the church because that's where she goes. She feels safe there. She's gone there all of her life. They failed to take into account what was right for her. And, you know, for example, just because my religious belief or my beliefs are this doesn't mean to say that someone else, you know, has, people have different things. And it's about putting yourself in that person's shoes and making a decision that's right for them. There is an appeal process directly linked to this, so people don't need to go to the Court of Protection where they don't agree with a decision. So you would normally challenge that via the direct appeal process. So that's our starting point in terms of pre-16 and then decision-making and capacity. So what we're doing now is we're going to have a think about if we've got someone over 16 and it is clear that they don't have capacity, do we need to go to the Court of Protection to ask them to give us power to make that decision or indeed for the court to make that decision for us? So what is the court? The Court of Protection is court in England and Wales, which is where we operate. Every part of the UK has slightly different law. It is largely a paper-based court. And it's quite funny to say that because the court still has people whose job is solely to get a file and match it with the incoming post. It literally does still work like that. And the reason to sort of highlight that to you is because when you make an application to the Court of Protection, for want of a better phrase, you need to bury the judge in all of the information the judge needs to make the decision. Because think about the fact that we're applying for something where we're not going to have a chat, we're not going to be able to explain things. Someone is sitting there in a chair like this, they get to read your application, it is one-dimensional. And so you have kind of one crack at getting all of that information to the judge. So, you know, again, empower, I love the word empower the judge to give us what we need. Because at the end of the day, every application to the judge, you know, can be rejected. It's not just a matter of a tick box exercise. So you apply to the judge for something, you know, in the regular course of way. If there's a a criminal case or something like that, judges, they decide based on facts. So it's a really good tip to always think about using the forms really well. And there's a form called a witness statement, a COP 24, and that gives you an opportunity to back up everything that you're saying. Anyway, I'll move on. The court separates financial decision-making from health and social care. So you can apply in both or in separate contexts. And as I've said there, it's usually post 16. Now, the time that we would normally come into contact with the court, more so to support families like you, is where we're applying for you to become the deputy of someone with TSC who lacks capacity to make decisions for themselves. So that's the most common area that we would be involved. But we can go to the court for a one-off decision in relation to financial and a one-off decision in relation to health and social care. Interestingly, and rather frustratingly, when we talk about the Court of Protection, the financial is called property and affairs, and health and social care is called personal welfare. You'll see when we talk about lasting powers of attorney that they're slightly different phrases, but for us today, it's simpler just to say financial and health and social care, because then we know what that means. I've put there a sort of a note below in the pale blue. This crosses over quite heavily to another webinar which we do, which is talking about planning for the future with wills and trusts. And in that, we explain why, where someone doesn't have capacity or isn't able to manage an inheritance, we have to set up a trust. And from us as parents, our inheritance goes straight into the trust to protect it for the individual. So that kind of crosses over to here because if there is a benefits package, which is managed as a DWP appointee, then that's great. And if all of the assets are held in a trust, we actually don't need to go to the court for any financial decision making. So it does, like I said, it crosses over to another webinar, which is a whole nother hour, but it's really important to try and filter that in here to get that thought process working. So what is a deputy and how does that work? Because like I said, that's the most common time we're going to come into contact with the court. So a deputy is someone that the court says can step into the shoes of the person who lacks capacity. So we're stepping into the shoes of that person, we're making decisions for them, be it financial or health and social care, or indeed both. Now, interestingly, it tends to be relatively easy to apply for a financial deputy order, but much more complex to apply for a health and social care deputy order. And I've put there some stats from 2017, which shows you how it was then. It's got better since then because there was a case in 2019 which challenged how judges were making their decisions about health and social care, health and social care deputy orders. And it sort of broke things down a little bit, but it is still vastly more complex and more challenging to get a health and social care deputy order than a financial order. And the reason for that is we would apply for a financial order where there's assets in someone's name and they lack capacity. So the easiest thing with us today to explain about it is that for an elderly person, they have a property and they develop dementia. So we need to deal with their property. The only way of doing that is going to the court to get a deputy order to deal with it. Health and social care wise, the court kicks back because of best interests and least restrictive option. So they use the Mental Capacity Act, quite rightly, the final 2 of the 5 core principles, to say, do you actually need this? Because in a health and social care decision-making arena, every decision for someone who lacks capacity should be made in that person's best interests under core principle number 4. So the court will say, well, why are you coming to me? Why is best interest not working? So if you get over that by saying to the judge, explaining to the judge why that's not working, the judge will say, well, why then is this not the most restrictive? Because again, the 5th core principle is the least restrictive option. And they'll be saying, well, actually a court order looks like the most restrictive way to do something. Can we do a one-off order? Can we do a little temporary order? Can we do something that's not quite so heavy-handed? Can you go without going to the court to do something yourself? So that's why I said it's really quite interesting from our point of view, how the court looks at those. And in the health and social care context, you have to get over both the best interests and least restrictive option problems to show to the judge why you need this deputy order. And there's no hard and fast rules about this, but the cases that we find that tend to be successful, and we do have failure as well as success, although touch wood at the moment, we've had more success than failure. The ones that tend to be more successful are the ones that have got more of a linked, complex health need. So blue lighting, something unique. I mean, you know, when we're looking at TSC, it would be someone who has more significant support needs rather than someone who has fewer support needs, because with fewer, the court will be sort of batting it back at you. So who can make the application? Who can be a deputy? That can be family, friends, professional people, mixture of that. We would always start by saying, why shouldn't you do it? Work with the family, work with the parents and carers. If not, you know, we as professionals, we are deputies for some people, friends can be. Now, another tip is that when you apply to become a deputy, as I said, paper-based, you apply, it's really quite useful to apply for more than one person to become a deputy, because if you think about myself and my wife applying in relation to my son, if, for example, I'm doing this and I'm not being interrupted and my son is blue lighted into hospital, then I really want my wife to be able to go and make decisions. Whereas if it was just me, no decision could be made. And picking up on that point, the way you've got more than one person, you would really, I would advocate having it as jointly and several, which then means, like I said, my wife can go off and do these things. The other option for the court is to have it jointly, and that means both of the deputies, or if there's three of them, all of them have to agree. So in the blue lighting kind of scenario, if my son's in hospital and a decision needs to be made, someone from the hospital would speak to my wife and she would say, I need this to be done, or I want this to be done, this is what I'm saying. Someone would then have to phone me and I would also have to give consent. So jointly can be quite challenging for us in this arena. So if you are applying to become a deputy, try and have more than one person and have it jointly, or apply for it to be jointly and severally. Like I said, the judge may decide not to do it. And I had a case quite a few years ago when a judge randomly decided that in the case I was applying, I had mum, brother and sister in relation to the other child. And the judge decided that they were going to be joint, and the brother, the mum was in the UK, sister was in the UK, brother was in the USA. And it was just like, well, that's not going to work. It's just not practical. So we went back and appealed and got what we wanted. But, you know, there are things that we, with the knowledge of this, can sort of share with you. Now, application to become a deputy is also not the world's most straightforward. The forms are on the gov.uk website, so you can do this yourself if you want to. However, it's not straightforward. At least 12 forms, at least 93 pages. The guidance, depending on which one you read, can be helpful, can not be helpful. The forms are not easy to interpret. And it's kind of also what you don't know, you're not putting in. And like I said, you know, applying paper-based wise, you know, you need to give as much information as you possibly can. So yes, you absolutely can do it yourself and you don't have to pay a lawyer to do it for you, but there is some benefit to be had having the support of a lawyer there. Now, there are currently 3 different applications depending upon what you need. And that's because we used to have 2, one financial, one health and social care. But Earlier this year, the court introduced a digital online process for straightforward financial applications. So we've got these sort of basic financial applications, which you download forms and load them up onto a digital process and answer questions. And that tends to be quicker, slicker, slightly easier. Then financial, more complex, which is fully in paper. And then health and social care, which is fully in paper because that is inherently complex in any case. So you've got all of these application forms. As part of the process and the starting part of the process, you always have to prove to the court that someone does not have capacity to make this decision, to do this thing themselves. So we go back to the beginning saying someone's got to give a capacity assessment. And again, that in itself can be challenging and also cost you money, could be £300, £500 to get that. As part of the process, irrespective of which one of the three you go for, you do have to give notice to family members and sometimes interested parties. And the reason for doing that is to save the sort of unscrupulous type of people taking advantage of someone. So it doesn't really apply to us, but because it's a procedural point, we have to do it. But you think about the dear old lady at home with no relatives, if someone's taking advantage of her, this element protects her. And notices are notices, they're notifications given to someone who then can object to the application going through. So in my context, if someone was applying in relation to me, my wife would get a notice, my brother would get a notice, and they would then say, well, actually, this isn't right. So it gives the court breathing space. There's a filtering process with health and social care deputy applications because you have to ask permission to proceed. So financial ones go through because, like I said, financial ones tend to be straightforward. You've got an asset, someone doesn't have capacity, it's pretty clear. The health and social care side, we've got to rebut the best interest and least restrictive option issues under the Mental Capacity Act. And part of that is the judge giving a sort of preliminary view about this going forward. So it's all done at the same time. It's not a separate process, but you have to do a tick box to say you need permission. And so it goes to a judge first to see whether there is enough there to go forward. And the judge could come back to you and say, there's not, throw it out, or come back to you and say, we need more information. So we then wind forward and hopefully we get a happy judge on a good day and we've given the judge everything and the judge says, yes, go ahead. So they then issue a notice saying we're going to go ahead, and for financial matters, you have to take out a deputy bond, which is kind of like a mini insurance policy. So because we're in charge of someone's finances, there's a mini insurance policy that if we then run off with their money, that then pays out. So just to reinforce, it is not the world's most simplest process. You can absolutely do it yourself if you want to by downloading the forms from the government website. Costs-wise, application fee, £371. There are fee exemptions if you're on certain benefits or have limited assets. The deputy bond fee, the insurance policy fee, it's not a set fee. It gets set by the underwriters based on risk of who is the deputy and the value of the assets being managed. There's supervision fees as well, between £35, £320, and you've got lawyers' fees if you consult them. So this is where I reinforce why we go back to the starting point to say, actually, what is it that you want to achieve? And let us figure out the best way of doing it, because deputy orders may not be. And you may have seen the light just dulled, and that's because I forgot to plug in my laptop on the juice. So bear with me while I bend down and just plug that in. There we go. Great. I'm not going to lose you. Or you're not going to lose me. I'm not going to lose the connection. There we go. Great. Timescale wise, it really depends upon which type of deputy order you're applying for. Like I said, the online one tends to be quicker, financial one sort of middle, or the financial more complex middle, and health and social care tends to be a bit later. During COVID, they were nearly all taking a year. Some now can go through in 16 weeks for the more online ones. But be prepared. It is not quick. It is not easy. And I've said here all along that we'd usually come into contact with the court 16 onwards, but actually we do come into contact with the court earlier for things like personal injury claims or criminal injury compensation authority claims, where we need the court's approval of the settlement. Well, that's the sort of the general time we'd get in contact with them. So that is the court of protection, and that is where we, as perhaps parents, are going to the court for help where we know someone doesn't have capacity. So let's flip this over and say that someone has mild TSC and they have capacity. Or indeed, for you as parents, don't sort of zone out during this section, because we should all have powers of attorney, and I'll explain why as we go through. But I'm going to focus on someone with TSC being able to do this themselves. So we've got someone, they are 18. And the interesting thing here is you have to be 18 to do it. And a power of attorney is a document whereby because I have capacity, I delegate my authority to someone to make decisions for me should I lose capacity. So in our arena today, lasting powers of attorney for people with TSC actually can be really super useful, because we don't know what the future holds. So if we have capacity today, then get these in place, because they're mini insurance policies for the future if we lose capacity. For you and I as parents, we need to do them for ourselves as well. So think very carefully about that. It doesn't take anything away from you. You are merely putting something in place, again, like an insurance policy, to say, if this happens, then this is the person who can take decisions for me. Basically, if you don't do this, then when we've got a problem, we have to go to the court of protection. So this is a much simpler, much more straightforward. It is also a system where we make decisions for us rather than relying on the judge. Lasting powers of attorney, they were introduced via the Mental Capacity Act, but actually took a couple of years to come into effect because the forms had to be drafted. And since then, the forms have changed quite a few times, and I think we've got a new system coming out maybe April, May time, more of a digital system. Who knows whether that will happen or be slightly delayed, but that's why, again, saying this talk is time sensitive. 20th of March 2024, it might be different by the time you see this or even action it. Again, we've got the separation between financial, health and social care. Different language though. For lasting powers of attorney, it's called property and financial affairs. For the health and social care, it's called health and welfare. But for us, again, financial, health and social care. Because we are doing, the person who has capacity is putting this in place, they then have the choice who can be their attorneys, the people who are making decisions for them. But it's the same kind of thing. Family, friends, professionals, you would expect the person to go down the family route unless there was a reason not to. We've got the same jointly or jointly and severally, or we can have a hybrid in this sort of situation where we have jointly for some and jointly and severally for other decisions. That can be a little bit challenging to get the wording correct on it, but it can help for some people. But just for you today, just go back to that. Like I said, jointly means that they both or three or four have to agree and sign something. Jointly and severally is the much more flexible option. The other great thing with the lasting power of attorney is that because you're doing it yourself, you have a chance to put in there 2 extra things. There are little boxes, but you can actually add supplementary boxes. You've got preferences and instructions. Instructions tend to be a positive or negative you can do or you can't do something. So with instructions, you have to be super careful because you don't want to limit the power of your attorneys, but also within the law, there are certain things that you can't authorize your attorneys to do. For example, gifting, and I'm going to talk about gifting in a little while. So instructions can be useful, but we have to be really careful with them. Preferences, however, are super useful because what preferences gives us the opportunity to do is to think about our personal thoughts, wishes, preferences in relation to the decision making that someone is making for us. So, for example, the easiest way to explain this is to think about my care. So I've lost capacity and I'm saying I would prefer to have care in my home whilst it's safe to do so and in my best interests. I would, if I have to go into a care home, I would prefer the care home to be in Brighton, close to the sea, because I love seeing the sea. I would prefer the care home to have a sort of animal-friendly policy because I like animals, and if someone brought in a dog, I would be very happy with that. I would like the care home to have lots of activities. As I said earlier, I go to the gym more or less every day at sort of 6 o'clock. I'm an active person. I would want to be involved. I'm also a sociable person. I want to be in the room with everybody doing stuff. I don't want to be in a room by myself. So they're the things that I would be saying to my attorney in my preferences, that if I lost capacity, these are the things which helps you decide on the decision to be made for me. There's also a safety net within the lasting power of attorney process, rather like the safety net that we have for the court of protection when we have to give notices. With the lasting power of attorney, the sort of safety net is the certificate provider that says that this is that the person who's making this document has capacity, but also that is in character for what we'd expect them to do, and they understand the lasting power of attorney and what it does. There's then a registration procedure, whereas with the Court of Protection, you go to the court. With lasting powers of attorney, you go to the Office of the Public Guardian. They used to be one and the same, and they've separated over years. So lasting powers of attorney, you go to the Office of the Public Guardian, and I've said there at the bottom, the registration fee is £82 per lasting power of attorney. But again, there are exemptions and exclusions on the fee depending upon your circumstances. So just, sort of look at the contra between Court of Protection application, £371, lasting powers of attorney, £82. Already a vast difference. So what about capacity to do lasting powers of attorney? Because actually for us now, thinking about it, where does that position ourselves? And there's the MCA, the Mental Capacity Act, states there's guidance, and there's also a guidance document. So I'm going to read that out word for word. I don't like doing that, but for this, I think it's really important. You must, so the person making the document, you must have the relevant information, retain it, and be able to weigh it up to arrive at the decision. You must understand what an LPA is, why you want to make it, who you're appointing as your attorneys, why you've chosen them, and what powers you're giving to them. So we're not expecting someone to come to me and say, I want to do a power of attorney, I know what it is, blah, blah, blah. I would normally, and certainly capacity assessors in this area, would explain what a power of attorney is. And then we tend to divert attention. So as I did with Luke earlier, not a diverting of attention thing, but I commented on something and said, are you a Liverpool supporter? Because Liverpool unfortunately lost on Sunday night. And then I might come back and say, oh, tell me what you think a lasting power of attorney is. Because I've told you what it is, I've diverted your attention, then I've come back to it to see if you can retain the information. So I've given you relevant, you've retained it. Then I need to find out whether you can weigh up and make the decision. So the questions that I'm asking are more so, who would you like to help you with your finances or help you operate your bank? Who would you like? Not, would you like mum and dad to do it? Because if I say, would you like mum and dad to do it, nodding my head, then someone who's very compliant will then say yes back. So it's an open-ended question to see if they have that level of capacity to understand. So great example of this. Same young lady, 23, Down syndrome. When we talked about who to be her attorneys, she said, my mum. And I said, oh, well, that's really interesting because I know you've got a mum and dad. I'd actually spoken to the mum and dad quite comprehensively. Why not your dad? And she said, because on Friday afternoons after work, he goes to the pub with his mates, and I would be sort of not, this is my words, not hers. I'd be fearful that he would spend my money on a pint of beer. And I said, oh, that's really, really interesting, because I know your dad, and I know he absolutely wouldn't do that with your money. He'd do it with his own. But what it demonstrated to me, which was the absolute breakthrough moment in the conversation, was she was able to weigh up the risks. So although she'd come to the wrong conclusion, she understood that by having an attorney, a financial attorney, they had access to her money and they could spend it however they wanted, albeit they're not meant to, and the law kind of stops them, but the law is reactive rather than proactive, so would stop them after the event. But she could see the risk, which meant that she could weigh up all of the potential problems. So it was an absolutely light bulb moment in that conversation. It was brilliant. So capacity around LPAs, is relatively complex. It's a relatively high level of capacity. And that's also why we often get independent capacity assessors involved, because getting an LPA in place can be so useful. We don't want to have it challenged in the future. So I'm just going to spend maybe 5 or so minutes doing some sort of wrapping up key points, and then I'll do a final wrap up before we go on to the Q&A. So just hold fire on posting your Q&A just at the moment, please. Appointee, I touched on it earlier. Appointee is someone who manages the benefits of someone who can't manage them for themselves. Largely, the authority comes from the DWP. That is super useful for families. And again, it ties into the will and trust, where we're saying that where someone is managing benefits and there are no assets in an individual's name, they shouldn't have to apply to the Court of Protection for a deputy order for financial decision making. So get this, because it really does help. Also, make sure you do the trust, because again, then we're avoiding any assets being in the name of someone who can't manage them themselves. I mentioned gifts earlier, and in particular, I mentioned it in relation to instructions in a lasting power of attorney, and saying that you can't actually give authority to make gifts because the law doesn't permit that. And again, this crosses over somewhat in relation to inheritances. Whether you are a Court of Protection deputy or an attorney under a lasting power of attorney, you only have authority to make customary gifts at things like birthdays and Christmas times. If you want to make a substantial gift, you have to apply to the Court of Protection for their authority. And that also extends to moving a inheritance or indeed assets out of an individual's name and into a trust, because that is still a gift. Any moving of the asset somewhere else is a gift. And we come across this a lot, and it's really worth explaining, where we have the very sad and unfortunate situation where someone dies and they leave assets directly to an individual who lacks capacity. Because when that happens, there is no option for the family but to apply to the Court of Protection for a financial deputy order to manage that inheritance. What families then realise is that that inheritance has also prejudiced means-tested benefits, because suddenly the individual's gone from having no money and claiming universal credit and other means-tested support to having £50,000 and therefore not being able to claim universal credit and means-tested support. So the family then say, well, why can't I just transfer it into trust, because I know anything in the discretionary or disabled person's trust is excluded from the means-tested benefit calculation. Unfortunately, again, that moving the money is a gift, and you won't be able to do it unless the court gives you authority. And at the moment, the court is saying there's no reason to give authority because the deceased should have done it themselves. So it's just something to highlight. Don't shoot the messenger. But if it is something that is important to you, seek some professional advice, because we see this a lot. We see people breaching their powers by doing this without knowing they shouldn't. And the effect on benefits also is pretty bad, because then you're claiming benefits when you shouldn't be. And that is quite serious. And the final point here on the sort of peripheral kind of thoughts is where we are talking about someone, particularly where they've inherited or indeed they've lost capacity, and either they don't have a will or they have a will which is vastly out of date, we actually can apply to the Court of Protection to have a will made for them. It's called a statutory will. It is not quick, it is not easy, it is not straightforward, it is not cheap. It is a very complex thing to do. However, it is super useful for some people. So it's just good to know that we can do this if we need to. The thing to remember, though, is that everybody can only make a will from the age of 18. So when we're applying to the court, it can only be post 18. We can't make a will for someone under 18 who has a big inheritance, or indeed a PI award or a Criminal Injuries Compensation Authority award. This is the quickest hour of my week when I do these. We've been talking for nearly an hour. How quickly does that go? However, hopefully now you have some knowledge that you didn't have at 10 o'clock, and you're thinking about, how do I go forward? So these are my tips to how you might go forward from here. Consider LPAs. Starting point is the lasting power of attorney for the person with TSC, or indeed for yourselves. If you need to make a decision for someone who lacks capacity, think about whether you need to go to the court. Do you need to go to the court? Because are there other things that can be done that saves you going to the court? Seek professional advice, specialist advice. I can't stress this enough. The mess we see from people who are not specialists in this area is just horrendous, and it costs the family so much more money. So I put some qualifications up there. Also, these days, just look at their website, because if they're specialists in this area, they will shout about it. If you click on ours, you'll see we've got photos of some of the families we support. So you know that we're inbuilt in this area. And I mentioned costs, check costs. We as lawyers have to be transparent with our clients about costs. And so I'm going to give you our costs. Again, it's correct as at today, the 20th of March, 2024, the lawyer's disclaimer, sorry about that. So if we were doing a Court of Protection deputy application for financial, our fee is £2,000 to £2,500 plus VAT. And for the health and social care deputy order application, our fee is £2,500 to £3,000 plus VAT. If we're doing them both at the same time, our fee is £4,000 to £4,500 plus VAT. And remember, the application fee, unless you can get exclusions, is £371. Lasting powers of attorney, however, vastly different. If an individual is doing both the financial and the health and social care at the same time, our fee is £1,100 plus VAT. And remember, the court fee is £82 per lasting power of attorney. So vastly, vastly different. Also, remember the LPA, quicker, cheaper, easier. Just to reinforce, you don't have to see a lawyer to do either the Court of Protection or the lasting powers of attorney. The forms are on the government website. So just wrapping up before I go to the Q&A, and feel free now, please, to start posting your questions. I do have some that are already prepared. In terms of going from here and engaging with us, you will be getting an email after today for those people who have attended live with a copy of the slides and details of how to engage with us if you would like support. Equally, there is a huge amount of information on our website. On the blog page, there's a search engine, so you can type in there wills, trusts, everything that I touched on but we didn't talk about today, but also more information about decision-making, Court of Protection, lasting powers of attorney. Also, follow us on X or indeed on Facebook, because we share loads of updates in the work that we're doing to support families like you. that's my details there. In terms of that coming to you, take a photo of it now if you want, but equally, like I said, you will get a copy of the slides with all of the contact details after today. And just before I open it up for questions and get my colleague Sarah to help me out with those, just to sort of mention about other events, because if you did want to come on the Planning for the Future event, we might well host one with TSA at a later date, but there is one coming up on Wednesday, the 10th of April. There's another decision making that we're doing on the 1st of May and a universal credit webinar on the 8th of May. All of the details are on our website on the events page. So I'm going to stop my share now. I'm going to make my lovely colleague Sarah, who's a caller protection specialist, co-host. So bear with me whilst I do that. Sarah, I'm going to find you first and get you over. There you are. So you'll now be joining me. I will stop my share. Everyone then should be able to see you as well as you come through. Hopefully. I'm waiting for that to happen. Everyone can see my face on big picture. Yep, there you are. The technology is working. Sarah, if you could turn your camera on and turn yourself off mute, that would be amazing. Lovely, there you are. Brilliant, fantastic. Sarah's actually in the office today, so it's great. Thanks, Sarah. So like I said, we actually have some questions that were sent through prior to today by Luke and his team, just to start us off. So Sarah, can you challenge a professional's decision following a capacity assessment?
So I'm not so sure about challenging being the right word, just purely because you would like to think that a professional capacity assessment would be done with good reason. But what you could do, as with anything, is ask for a second opinion. So you could ask that assessor to go back maybe at another time or another day, etc., or approach it a different way. Or alternatively, you could ask a completely different assessor to just go and see if somebody completely neutral and independent reach the same view. And the other thing is to think about timing in between when a capacity assessment has happened. So if you're not quite sure about the result, or if you're unhappy with it, then maybe look at when it was carried out, how the circumstances around it. Was it in a clinical setting? Would your loved one maybe feel more relaxed in a different environment, maybe at home? So just have a look at all of those things and look at getting a second opinion.
Yeah, and it ties in with that sort of the maximizing decision-making capacity, doesn't it? Like you said, surroundings, if the initial assessment, the surroundings weren't comfortable, it could come out wrong. So
Exactly.
yeah, play about with everything that we've talked about. Brilliant. Thank you, Sarah. So the next question, and it sort of follows on from this. Is there an amount of time you must wait following a capacity assessment before you can request another?
So the short answer is no. There's no deadline for when you how long you have to wait, but it goes back to what we just said about having a think about how tricky it might be to have a capacity assessment, and then if you had one the following day, that might be a bit much for us. It could be quite an overwhelming process. It's meeting someone brand new. Again, it's going through a process that might be in a clinical or an unfamiliar setting, and just have a think about that. So no is the short answer. There's no amount of time you have to wait, but just bear in mind that it might be a little bit overwhelming to have one and then another in a short space of time. Equally, it's worth not leaving it too long, so that if you get an outcome on day one, if you have another assessment 2 months later, a lot can happen in that time. So maybe just try and strike a balance between it not being too overwhelming, but it not being too far apart.
Yeah. And again, I guess, it sort of just reinforces everybody's an individual. And so there's no hard and fast rules about anything we're saying today, really, because it's about that person and finding out about them. Brilliant, thank you. So the next two questions sort of merge a bit. So I'm going to read them all out and then perhaps we'll take them all together because the answer tends to be quite similar. So what happens when someone lacks capacity but the family cannot afford the costs of applying for deputyship. Who would make the decisions? And in the same vein, what happens if decisions need to be made whilst your application is going through? So I think basically they're both saying the same thing, that we need to make decisions, but the deputyship has not been issued because we've either not applied or it's in the process.
So strictly speaking, as you will have touched on earlier, you can't make decisions without authority. So in the absence of a registered power of attorney, in the absence of a deputy order, strictly speaking, you can't make those decisions. Nobody is authorised. At least that's the case on the property and financial side of things. So you'd have to find workarounds, and we can advise on that. If families are in that position, that they can come to us and we can give them practical tips. But in terms of personal welfare, health and welfare matters, there's so much infrastructure within local authorities, clinical settings, the NHS, etc., where best interests decisions and meetings and focus groups, basically, for the benefit of that person, they broadly can work with families to make decisions. So it doesn't mean it's a complete barrier on that side, but try and exhaust every available option without straying into doing things you're not allowed to do. And if you're unsure, as you said earlier, just seek appropriate advice. Go and ask the right questions. And in terms for completeness, you can go to the Court of Protection for interim and even urgent orders, and then the very unusual ones would be emergency orders. They're much more rare, but you can go to the court and say, we are in a pickle, it is urgent, we need a decision to be made. And generally those applications are processed with genuine speed and attention, but you always have to be careful that they take a dim view on claiming something is urgent when it's not really. So again, my headline response to that would be take advice if you're at all unsure.
Yeah, and you touched on there, the court tends to have not enough staff, not enough judges, too much work. So they do really frown upon things where you shouldn't make the application. So yeah, just be careful about that. That was a really good point. I'm now going to start taking the live questions, but as we're doing that, it would be brilliant if we can get some feedback as well, because TSA and us will love to get that together to see whether this has been useful for you, to see whether we can learn from it, or indeed, it's been fantastic and there's nothing to learn from it. So if, as part of putting the questions in there, you can put some feedback as well, that would be brilliant. Thank you. So the first question is quite interesting because I'm not sure this one is right, but Sarah, you might well know something I don't. So, and I'm not challenging you on this, but this says, why is it that a DOLS is acceptable for a financial COP, but for the health and social care, you need the COP3, which is the assessment of capacity, to be completed? I thought, well, in my mind, you need the COP3, the assessment of capacity, for financial and for health and social care. I've never heard of a DOLS order replacing a COP3. Have you?
Not something I've come across. I wonder if there's some cross-pollination going on there, in terms of maybe advice being given, or yeah, my understanding, that's not applicable at all. And actually there's not very much interaction. There is some often, but there isn't very much interaction between a property financial LPA or deputyship and a DOLS. That comes under the DOLS element, the safeguarding of what someone can and can't do and where they can and can't go, comes under personal welfare, and the COP3 is usually required, or at least an assessment, even if it wasn't in a COP3 format. So I think there might be some blurring of elements.
Yeah. And often you get asked for sight of the DOLS order or confirmation the DOLS has been undertaken on the health and social care, because it's integral in the judge knowing what's going on. But
yeah, exactly.
Yeah, not a replacement of the assessment. So
I've never come across that in practice.
No, thank you. This is a bit of a lengthy one, but it's quite good because and I'm going to summarize it, so forgive me for the person who's there for summarizing it. They are referring to MenCap's LPA pack, which we use. So MenCap, it's actually MenCap Trust Company, have a really good, easy read guide which you can use when talking to someone about LPAs. So it says, is it okay to spend time explaining the LPA to him in very simple terms before we get the capacity assessment?
I mean, I'd say absolutely. You'd want to know, it would be very unfair to have an assessment. I respect the question, I completely understand. But yes, it's absolutely appropriate that someone who's going to be asked to give an opinion on powers of attorney in this case, that they know broadly what that is, and that they have they're equipped going in. So there's a difference between informing them and talking it through it with them and explaining the concepts, and coaching. So where you've got people who are trying to say, when you get asked this, say that. That is very different to sitting down and taking the time to explain what something does and doesn't do and getting their opinion. So that's absolutely fine.
Yeah, and we love the MenCap Trust Company Easy Read Guide. You and I used it for someone recently,
Yes,
and yeah, we did exactly that, didn't we? We gave it to the mum to have these conversations with her, and when she came in, even without prompting, she went through "I don't want," and actually she said some really great things, didn't she? I don't want someone to choose my friends for me or my food or
yeah.
something.
Yeah, she said, I would like some help with where I live. She said, I wouldn't
Yeah,
know if it's a good area or a bad area, but
yeah.
I know who I like, and I don't want someone to say who I can't be friends with. And she showed real balance and insight into the two and the distinction between the two.
Yeah, and again, that kind of gave us that inherent confidence that she had capacity, because she was able to weigh up and she was saying, I do want help here because actually I understand that I can't do that, and money management and, like you said, where you live. But she also knew that she didn't want anyone interfering with her friendship and
Yeah.
actually food choices as well, wasn't it?
Yeah, that's right. Yeah.
Yeah. The next one again, just I've not heard of this, and the person who's wrote this may need to do a little top-up question, but Sarah, you might have heard of this. And they've used sort of a capitals for this. Are circles of support, so circles of support, helpful for getting a more holistic approach to best interest decisions? So circles of support, the way it's been written is it's if it's a thing, a document or something, rather than a sort of a phrase. My context of a circle of support is, yes, in best interest, you would have that. But have you heard of a document or anything called a circle of support?
It's not something I've come across, so happy to be educated.
Yeah,
But no,
yeah.
not something I've seen as a standardized framework or a document. No.
No. And if this person wants to, post a top up, then great. But if we're doing if there was a best interest decision, as we said, it's a multidisciplinary approach. Again, you would probably want to think very carefully about all of the sort of what am I trying to say? It's been an hour and a quarter, forgive me. I have no mental capacity left. The sort of research that you do before you go in the meeting, don't you? Because
Yeah.
with the best interest, you want to have all of that research in place, all of your facts absolutely correct. So yeah, thank you. Sorry, forgive me. My brain has just fried. So we don't have any more open questions. So what I'm going to do is to bring things to a close. I'm going to leave the Q&A open, if I may, just ask for feedback. Feedback would be amazing. Thank you so much for joining us today. Hopefully it was helpful. Hopefully you've learned something from there. And like I said, if you'd like to engage with us, then please do. You'll probably see Sarah, because Sarah, alongside myself, is our caller protection specialist. I tend to be off doing loads of different things. So Sarah's based in the office and you are more likely to speak to her than myself. But Sarah, thank you. Luke, if you are there, if you could come online, I will say goodbye and hand over to you. Luke, are you there? Let's have a look and see if you are there. You are there. Ah, for some reason you've come off panelist. I'll put you back onto panelist, Luke. Sorry about that. And while Luke is talking, if you can continue posting the feedback, that would be amazing. Luke, there you are. Amazing.
Yeah, still here.
Thank you. Sorry, that must have been me. I must have clicked on something odd.
Yeah, no worries, no worries. Yeah. Just very quickly to say thank you both Philip and Sarah. That was so. I feel like I've learned so much. It's such a complicated area. It's brilliant to get this overview and the recording, as we said previously, and some brilliant questions as well. So yeah, thank you for people who ask questions. Yeah, so that's really all I wanted to say. So yeah, thank you very much. Like I said, this has been wonderful. If anyone does have questions, more broadly after this about anything, do be sure to get in contact with us, and we will signpost as needed, most likely to to yourselves. And yeah, we're good. Keep an eye out for other events as well. But yeah, that's everything I wanted to say, really. Yeah, all good.
Brilliant. Thank you so much. I'm going to leave the Q&A open for 5 minutes or so people have got a chance to put in the feedback, and then we'll share the recordings so that TSA have that. Thanks very much for inviting us.
Thank you very much. Thank you.
Thanks
Bye-bye.
very much. Bye.
Bye-bye.